You're not anti-AI, you're anti-risk. And if you said no to adopting AI so far in your legal practice, it's probably not because you're against technology. It's because every AI pitch you've heard so far sounds more like a gamble than a strategy. The hard truth most salespeople won't tell you is that their AI tools will fail unless you evaluate them specifically in the context of your law firm. In this video, I'll show you why bad evaluation practices are silently killing AI projects, how to spot risks before they happen, and the specific evaluation method you can use to adopt AI safely in your firm without any guessing, hype, or gambling with your client confidentiality. I'm Rok, and I've built AI in highly regulated industries where one mistake could mean huge lawsuits. Now, I help legal teams apply the same safety standards. Let's start with the core problem. You're being asked to bet on black box results. Every AI vendor has a demo, dashboard, and very confident claims. But what almost none provide, and what most firms forget to ask for, is this. How do we know that this tool is actually compliant, safe, and accurate enough for our work? That's not a philosophical question. That's a risk management obligation. Because if you cannot defend the output or explain how it was validated, you are the one holding the liability. What happens without a good evaluation? Let me walk you through 3 real-world patterns I see all the time when evaluations go wrong. The first one is shadow adoption. Imagine associate testing ChatGPT to draft a clause, or a paralegal editing an AI written summary, without any policy or any kind of audit trail. Why this is dangerous? Because now you have AI surfacing in client matters without compliance review or confidentiality safeguards. That's malpractice exposure waiting to happen. The second one is enterprise theater. And what do I mean by that? Leadership brings in big law tools. There's trainings, kickoff webinar, maybe even a pilot. Why this is dangerous? Because big law workflow never fits your team's reality. The tool sits unused and you're left with cost, confusion, and another reason to distrust innovation. The third one is legal aid logic. What happens? You test a flashy AI product on a basic legal research task. It performs well, so you assume it's safe for broader use. Why this is dangerous? Because this is like evaluating a paralegal on a traffic ticket and then giving them $1 billion due diligence review. Context matters. Tools that look good on easy tasks collapse on real legal tasks. And by the time you find out, the damage has already been done. If this sounds familiar in your practice, book a free legal AI risk check and we'll go through this together in a call. Link is in the description below. And so, what does a good evaluation look like? A good evaluation is not about features or what AI can do. It's not about hallucination rates in the lab either. It's about your real work, under your real risks, and in your real system. Here's how we do it. The first step is map where AI is already creeping into your firm. Intake, drafting, legal research. You need to flag the zones that touch confidentiality, privilege, and compliance before testing a tool. Step 2, vendor compliance gate. Either approve this or stop right here. Before AI outputs, get hard proof of data handling of any kind of AI tool or platform. Ask questions such as, where is our data processed? You need a specific jurisdiction in writing, ideally where your clients expect their data to live. Red flags here, terms like in the cloud, it lives in global infrastructure, or any kind of answer that doesn't lock the data to a specific jurisdiction. Second is the data used for training. You want a flat no in writing. Red flag is anonymized. I mean, nobody ever tells us how they're anonymizing the data. And you want to turn away when they say may improve our models. Third one, the data retention. You want delete on demand or retaining less than 30 days. The red flag is it depends. However, we need it for providing the services or we don't delete. Fourth one, you want cross-border guarantees. Safe is it won't leave our jurisdiction. It's in our DPA. Some red flags, hedging and policy links without commitments. The fifth one, data processing agreement and audit logs. What is safe? A countersigned DPA and exportable audit logs. Who, what, when. Some red flags, no logs, or use our general terms. If you want to know more, I dedicated a video on the topic of which questions you should ask your vendor. I'm linking it up here. Step number 3 is real task evaluation. Forget the generic benchmarks. Test tools on your actual inputs, forms, and documents. Intake, clauses, internal memos. If it cannot produce an output that your team would confidently use, it failed. Simple as that. Where I see most firms going wrong is they rely on impressions instead of evidence. To keep this practical, let me show you how you can do 3 quick stress tests, all with your own documents. First one, cite or refuse. Ask a question where the answer exists in your docs. Now the safe tool would quote the clause and show you where the answer came from. The unsafe tool, on the other hand, would just answer, with no proof. Second one, unanswerable drill. Now you ask a question that your docs cannot answer. Now the safe tool here says insufficient evidence, while the unsafe tool would just make up an answer. The third one, jurisdiction check. Say we have both Dutch clause and an Italian version of similar clause in your knowledge base. The safe tool would tell you the difference and ask you which one applies. The unsafe tool would just mix them both together and just give you an answer. If the tool cannot pass those 3 stress tests, it doesn't matter how good the demo looks, and it really doesn't matter how good your relationship with the founder is. You just shouldn't use it. Now, how you can score that? In the green section, we put all the tools where answers are cited and verifiable. This is the confidentiality gate, passed. In the amber section, we put the mixed tools. Those are the ones that give us mixed or partial citations, and they need human review. In the red section, we put the tools that produce the answers with missing resources, wrong jurisdiction, or made-up answers and wrong answers altogether. We don't use those tools. And any red on confidentiality should be an automatic fail. Step number 4 is defense-ready review. That's your insurer regulator packet. A proper evaluation shouldn't end with the tool worked. It should end with a defensible record. The kind of file you can show to a regulator, an insurer, or in discovery. Now that would mean documenting the following. Reasonables. Why the tool is being used, where it helps, and what the limits are. 2. Evidence. Vendor assurances, sample outputs, and citations proving accuracy. 3. Supervision. Who reviews its outputs, how often, and under what controls. 4. Audit trails. Exported logs showing what was tested, when, and by whom. Filed properly, this becomes part of your compliance record. Now we came to the step 5, which is pilot in your flow. Even a capable tool would fail when tested out of context. That's why you need to pilot within your existing workflow. Fragmented document sources, messy or heterogeneous data, already existing in-house templates, and established review practices. A tool unable to function in these conditions will likely not withstand the realities of live client matter. Okay, we talked about what to do and how to do it, but let's spend a minute talking about what not to do. If you're evaluating, do not evaluate vendors by their demos or their landing pages. Just don't. That's like recruiting an associate based solely on their TikTok law exam performance. Technical ability does not equal meeting your professional legal requirements. In your field, every decision around technology is a legal risk. Test it where your liability lives. Real example. One 9-person firm I advised assumed an AI summarization tool would help with their client intake. And it looked great in the demo presentation. Flawless. But when we tested it with 50 of their real examples of client intake forms, disaster. 27 misses of key eligibility details, 8 inferences implying liability, and 5 completely fabricated responses that would have required an ethics inquiry. Yet, in a smaller firm where we tested the same AI tool, it excelled. The difference, the context, and the data they had. And so, with a bigger firm, the right evaluation approach protected the firm against malpractice. And also, we identified a practical and hidden safe win they didn't expect. So the key takeaway today is that AI itself is not the risk, but blind adoption is. And so is the ignorance of what your team is already using. And on top of everything, so is evaluating an AI tool based on hype and impressions, and not based on how it performs inside of your workflows. Because a strong evaluation process gives you two things: proof that you can use AI safely under the standards that your clients expect and deserve, and the confidence that when you say no, it's based on data and insights and not fear. If you're cautious about AI, good. That's exactly what protects your clients, your license, and your reputation. But don't let caution become paralysis. With the right evaluation process, you can replace the trust gap with clarity and adopt AI where it truly fits, safely and responsibly. And so if you want help evaluating any AI tool, or just want clarity on your firm's situation, I offer a free legal AI risk check, a short private call where we map where AI is already showing up in your workflows and flag your biggest compliance gaps. The link is below to book your slot. Follow along for more plain English legal AI guidance. See you in the next one.